right, sir, in Otsego County, can you tell me your name, please?
Jod Phillips.
Okay, we'll go on the record in People versus Jod Phillips. This is file number 255438. The record should reflect that Mr. Phillips is present by video from Otsego County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trushbury on behalf of Mr. Phillips. Your Honor, this is a case I substituted in for Mr. Thompson, I think a couple weeks ago. I got appointed to Mr. Phillips over in Otsego County, and it just made more sense in that circumstance for me to have the case than Mr. Thompson. In Otsego, I think a week or two ago, we waived the preliminary exam, so our matter there is headed up to circuit court. That's a more significant charge than the charge here. And ultimately, I'm going to ask for an adjournment so we can let the other case get up there, and I can have some discussions with Ms. Koch as well as Mr. Rolla in terms of potential global resolutions to take care of all the matters.
How much of an adjournment are you asking for?
We waived the exam, I want to say a week or two ago, so likely we're going to be on the October motion week. So I think 30 days would probably be enough. And I feel confident, even if at that stage, if we're not fully ready, I think we'll have a strong idea of where we're going.
Do you know if that case has been assigned to a judge or following find over yet?
I don't think it has. I haven't received a date yet.
Okay, all right. Ms. Koch.
Your Honor, I wanted to check the status of his bond here. We didn't revoke his bond because he's lodged in Otsego on the delivery case up there. I think that's what my notes are confusing. I think we went to revoke it because he didn't show up, and then we rescinded the bench warrant. This is on 7/15. So I'm just trying to see where we're at.
The bond was revoked and the bench warrant issued on 8/28.
I recall getting an order revoking his bond.
Okay.
We don't have to worry about that.
Yeah, at least at this stage, I don't think there's any, well, at this junction in the posture of the cases, I'm not going to make an argument against it.
Okay.
That's really what I want to know. I have no objection to adjourning it, and I can talk to Mr. Rolla and Mr. Trush, find out a little bit about what's happening in his Otsego case.
All right, so I'll just set this for another status conference in about 30 days. We'll go forward at that time. Mr. Phillips, were you able to hear all of that?
Yes, sir. I heard it.
Okay. Do you have any questions at all?
At this point, I do not. I would just like to know if my lawyer will be in contact with me anytime soon so we could discuss this. Other than that, I have no video feed. I don't know if that means anything or not, but yeah, I don't think I have a question. I don't have a question for the court at this time. No, sir.
Yeah, I'll be over there to talk to you pretty soon. Okay.
Yes, sir. Thank you, Mr. Trush.
Okay, thank you. We're going to go ahead and disconnect at this time, Mr. Phillips.
Okay, thank you very much.
Sir, what's your name? Joshua Johnson. Mr. Johnson. Okay. We'll follow People versus Johnson. File number 2554440 and 2555464.
Sierra Coke on behalf of the people.
Good morning, Your Honor. David Barber on behalf of Mr. Johnson, who's currently incarcerated in the Crawford. And my right. Would you like me at the podium, Your Honor, at the table?
Podium, please. Thank you. This is set for status conference, scheduling conference in both files today. Mr. Barber, can you tell me kind of where things are at from the defense standpoint?
Your Honor, at this time, Mr. Johnson is prepared to enter a plea. The court would be willing to accept a plea today.
Okay.
We have had discussions with the prosecuting attorney regarding resolving all files. We do have a resolution, I believe, that will resolve all pending matters in this county.
Can you tell me what the terms of the agreement are?
Yes, Your Honor. And I guess if there's any issue, just correct me if I'm wrong, Sierra, but Your Honor, it's my understanding that Mr. Johnson will be pleading to a domestic violence with the third offense notice in file
5440.
Yeah.
It will be an amended count 3 on that file.
Dismiss the strangulation and home invasion.
Okay. So add count 3 of domestic violence, third offense, and file 5440.
Correct.
Okay,
And then on file,
5464.
he would be pleading to a domestic violence second offense and an OWI.
That is correct, Your Honor.
so the OWI is going to be an added count 3 in that file, as opposed to IPAC.
Yes.
This would be first OWI.
Yes.
93 days.
Yes.
Second is a 1 year. Is that correct?
It is.
Correct.
So, Mr. Johnson, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes,
And is that how you wanted to proceed today?
yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Very good. Mr. Johnson, are you currently on any kind of probation or parole?
Yes, Your Honor.
Okay, where's that out of?
Otsego and Crawford probation.
So you have separate files in each of those counties that you're on probation for?
Yes, sir.
All right, you understand that, Mr. Rivera, is this going to affect his probation in some way?
We will, Your Honor. We've had discussions with that, so he's aware of this may impact that as well.
Okay, so you understand that you could face additional penalties over and above what you would face in this case based on a violation of your probation. And Mr. Barberi or Ms. Koch, are either of you aware of any potential either mandatory or discretionary consecutive sentencing sanctions in this case?
No, Your Honor.
No, Your Honor.
Okay.
So in addition to potential penalties for violating your probation in those other cases, Mr. Johnson, the maximum possible penalty you could face for domestic violence third offense is up to 5 years and or a $5,000 fine. You understand?
Yes, Your Honor.
And the maximum possible penalty for domestic violence second offense is up to 1 year in jail. Do you understand that?
Yes, Your Honor.
And then the maximum possible penalty for operating while intoxicated is a 93-day misdemeanor. Do you understand that?
Yes, Your Honor.
With all of those potential penalties in mind, including the probation violations, what is your plea to each of those 3 charges here today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you want it. You understand all those rights?
Yes, Your Honor.
Understand that you're going to be giving up, waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal it by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything? Be guilty to any of these charges?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today? Or
No, Your Honor.
is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
So let's see. So the first incident took place on May 23rd of 2025, is that correct?
Yes, Your Honor.
Okay. And on that date, did you get into some type of altercation with Mertz and Jod Phillips?
Yes, Your Honor.
Where did that happen at?
At her residence.
Where's that located?
6363 Karen. Regarding issues.
Okay, so here in Grayling.
Yes, Your Honor.
And was that a person, were you in a dating relationship with that person?
Yes, Your Honor.
right, what happened during that altercation that would make you guilty of domestic assault?
I physically assaulted her, Your Honor.
Okay. Did you have any kind of justification for doing that anyway?
No,
And that was against her will?
yes, Your Honor.
Had you previously been convicted of the offense of domestic violence?
Yes, Your Honor.
Okay. And is that on or about October 31st of 2024, District Court of Mexico County?
Yes, Your Honor.
Right, and then there was another incident on June 19th of 2025, is that correct?
Yes, Your Honor.
Okay, and did that occur at that same residence and I'm here?
Yes, Your Honor.
That involved the same individual, Madison Gentilla?
Yes, Your Honor.
What did you do in that situation that would make you guilty of assault?
I was physically assaulted.
And again, was that against her will?
Yes, Your Honor.
Did you have any justification for assaulting her at that time?
No, Your Honor.
All right, are we gonna use the offensive file 440 as, actually, I guess we don't need to. Had you also been convicted here in Crawford County in in April of 2025 of domestic assault?
Yes, Your Honor.
Did, okay, so we have the basis for the third on that one. On that day in June, on June 19th, 2025, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol on that day, did you operate a motor vehicle on Nelson Miles Parkway here in Crawford County?
Yes, Your Honor.
And did you get pulled over, or how did you encounter police?
Yes, I got pulled over.
Did they do any breath or blood tests to determine the level of alcohol in your system?
Blood test.
Do you remember what the result was?
I believe it was like 2, 3, 4.
Okay. Do you have any reason to doubt the accuracy of that test?
No, Your Honor.
Had you consumed enough alcohol on that day that you believe that your blood alcohol level could have been that high?
Yes, Your Honor.
All right, Ms. Koch, are the people satisfied with the factual basis as to the charges here?
Yes, Your Honor.
Mr. Barberry?
I am, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Barberry?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court will take?
Yes, Your Honor.
Mr. Barberry?
Yes, Your Honor.
Mr. Johnson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. Set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing, as will your attorney. Between now and then, someone will be contacted for a sentence report. You have an opportunity once that's prepared to go through that with your lawyer prior to sentencing. Ms. Koch, is there anything further to address
No, thank you.
on either of these files?
No, nothing on the files, Your Honor. I just had a question regarding sentencing date. Roughly when will that be?
It should be in about 30 days.
And when typically do we receive notice of that?
Relatively quickly.
Okay.
I think my assistant should have that out by next week.
Okay.
It'll probably be 10/9,
10/9.
if I had to guess. That's his first motion day in October.
Okay.
Yes.
Well, thank you, Your Honor.
Thank you. That's all I have to say, Mr. Chairman. Okay. Mr. Beckman present.
Yes, thank you. Now,
Mr. Beckman can come forward, please.
podium right there.
Yes. Okay, please. All right, Mr. Green, are you able to hear me okay?
Yes, I am.
We'll go on the record in people versus. This is file number 255378. The record should reflect that Mr. Beckman is present here in the courtroom today. If I could just have both counsel put your appearances on.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Jeremiah Beckman.
Okay, this is the date and time set for sentencing in this matter. Mr. Beckman, you had an opportunity to go through the report with Mr. Thompson.
Yes, I have.
Okay. Mr. Thompson, are there any corrections that need to be made to that report?
There are not.
Okay, and this is going to be a delay. Is that correct?
That's correct, Your Honor.
Mr. Green, do the people have any changes to the body of the report at all?
No, Your Honor, I've been through it, no changes.
Okay. Mr. Green, anything you wanted to say on behalf of the people for elocution today?
Only that so far, Mr. Beckman seems to be showing good faith in following through on the agreement. So we're comfortable with our offer for the 11-month delay plus details.
All right, thank you. Mr. Thompson, anything on behalf of Mr. Beckman?
I would agree with fellow counsel. I think Mr. Beckman has been showing good faith. He's been making payments. He's been doing the best he can. We were talking out in the hallway and I told him I thought it was simple, but not easy. You know, he needs to keep making payments on this. And I know that's very difficult. He's limited financial resources, but he is doing the best he can. And I have a lot of confidence he will continue to do that. And when we're before Your Honor in a year, he will have earned the opportunity that the court is granting. Thank you.
Mr. Beckman, anything you wanted to say today?
No, there's not.
Okay.
Just trying what I can do.
So I read through the report. I think this is a fair solution to this problem, to get some money flowing, to try and make some progress on the arrears and continue moving forward. I agree completely with Mr. Thompson. It's very simple, but not necessarily easy. I think, for you, the key is, number one, following the terms of this delay, but to the extent that you're having issues with that, is communication. Prosecutor's office, communication with your attorney, if you need that, to get ahead of that problem, as opposed to just ignoring it or hoping it's going to go away, because you're going to wind up getting yourself in more trouble. Typically, in these kind of situations, if you have some open and frank communication, problems can be solved. It's when you just ignore it, don't do anything about it, and then you end up back here. Okay, correct. So I am going to follow the recommendation. We're going to place you on a delay of sentence for a period of 11 months. The court is going to adopt as the conditions of that delay all the terms and conditions in the report. The most important of which, of course, is that you continue to make child support payments according to the agreement. The court is also going to order a crime victim assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, and $30 per month while you're on the delay of sentence. I can tell you this, Mr. Beckman, that if you comply with all the terms, you make your child support payments, and if we're back here in 11 months and the only thing that you haven't done is pay court costs and attorney fees, which is $675, I would be willing to waive those. It's more important to me that you're making than those two things. The other fines and costs I can't do anything about, but mandated by statute.
I understand.
So that could be an added incentive for you. You can save yourself $675, which would go more towards that child support. Okay. Because this is a delay, there are no appellate rights at this time. Mr. Green, is there anything else that I can address for your side?
I don't believe so, Your Honor. Thank you.
Mr. Thompson?
Nothing further for today's record. Thank you, Your Honor.
Okay. Thank you. That's all for today, Mr. Beckman. Good luck.
Thank you very much.
Thank you, Your Honor. Have a good morning.
Thank you. You're free to disconnect at this time.
Thank you.
Mr. Lovell has not, and Mr. Truitt have cases. That's fine. So as soon as he finishes up with this document, he will be back.
Oh. All right, we'll take a short recess.
Judge.
Yes. Mr. Lovely is? Okay, great. Well, actually, we don't have his attorney, so.
Can I speak to Mr. Clark for a moment?
Sure.
Thank you.
YouTube, but they cannot see.
Just back there.